Welcome back to Divinity Said. I am Divinity, and I have clipped down the 4-hour motions hearing yesterday to this 1-hour video so you can get to the meat of the arguments, both from Brian Koberger's defense and from the state of Idaho. If you are unfamiliar, Brian Koberger is charged with the quadruple homicide of 4 teenage college students in November of 2022, and his trial is set. Pre-trial starts in May. Jury selection will begin in August, and we should be in trial. Basically, it'll be a year from today. So keep yourself up to date. Let's find out. Judging by the judge, I think this is going to be a death penalty case, but you never know what he's going to decide. When he decides, I'll put out a new video and let you know.
The first matter we have to take up this morning is the objection to the testimony of Dr. Barbara Wolf related to the method of execution. So let's proceed with that. The state can be heard.
Thank you, Your Honor. Our objection on this witness is really just the ripeness issue. We think that this claim is quite clearly several decades early at this point in time, and that's assuming that there's a conviction and imposition of the death penalty. And so we're just trying to save everyone time and would ask that the court find this issue is not ripe before we have an evidentiary hearing on it.
All right.
That's the extent of the objection.
All right.
Thank you, Your Honor.
Your Honor, Dr. Wolf's proposed testimony is important for the court to hear and to think about the larger issue, and that is Idaho's inability to execute somebody at the given time. And there's a constitutional issue with having somebody sit on death row when there's no meaningful way for them to be executed. And Dr. Wolf's testimony will highlight for the court some information that may come up if Mr. Koberger's ever convicted, and if there's a death penalty, and if he faces the firing squad. Your Honor, I think that Dr. Wolf's testimony would provide the court with information about conscious pain and suffering, awareness of that pain and suffering, which matters for the Eighth Amendment, as well as why that information is known by her now. It's more recent information. It's after Idaho's history of having the firing squad and then removing it in light of the Bayes decision, and then in 2023 instituting it again. But this information about consciousness of pain and suffering happens in that window between 2009 and 2023. And I think the court should consider that and have that information.
Thank you. All right. The court having reviewed the materials, believes that given the concerns about the current justiciability of the, or ripeness, if you will, of the issue, I do believe that the declaration is a sufficient proffer of what that general testimony would be that would allow us to discuss the issue. And so for the time being, I'm not going to hear from Ms. Wolf, or Dr. Wolf, I should say, her testimony.
We think that the court ought to strike the death penalty in this case and not allow the case to go forward as a death penalty case, because Idaho does not have a current means of executing anybody. When somebody sits on death row and there's no real means of executing them, that is dehumanizing to that person. That's similar.
You say there's no means, under Idaho law, the method of execution is lethal injection, and if unavailable, then the firing squad. You rely significantly on the idea that lethal injection is not available based upon the quote-unquote botched execution of Mr. Creech. It seems to me that was a particularized incident wherein Mr. Creech, the execution really hadn't even begun yet, in the sense that they couldn't locate a vein. I don't see how that issue is universal.
Your Honor, I would agree that Mr. Creech's, the situation that happened to him was unique to him. I don't think he's the only person that has ever had that happen. I'm not in the state of Idaho, but I think that that's happened before when the means of execution couldn't be employed at the time. But since we're talking about Idaho, I think we should look at what happened in the Pizzuto case too. And in that case, there was no ability to obtain the chemicals to kill him with. And so his execution, his death warrant expired without him being executed. After that happened, Idaho passed legislation that would allow the Department of Corrections to obtain the chemicals to kill somebody in secrecy. After that happened, there's still a lot of difficulty getting the chemicals because pharmaceutical companies don't like to have
They
their...
have obtained them twice now, since then.
They've obtained them twice for Creech, yes. Now, something has changed in the death chamber for how they will try to execute Creech. I don't know what that is. That's probably one of those things that we'll learn a little bit more about through Creech's.
Well, I think that they're going to utilize a central venous catheter. In other words, accessing a central vein rather than a peripheral vein. My understanding that there's federal law approving that procedure, as well as a recent decision by the district court approving that procedure.
You know, looking forward, we just don't have those answers yet. We don't know how that's going to unfold. I don't believe his execution is moving forward as is scheduled. And if we look at the immediate history in Idaho, and that's what I'm looking at when I'm standing before you representing Mr. Koberger and saying to you that Idaho doesn't have a real means of executing someone. The firing squad ended up on the books because of the difficulty obtaining the drugs to kill somebody. That's why the firing squad came back. The history of the firing squad, which is really well written by Mr. Logston in our briefing, is that it sat on Idaho's books for years. And in 2009, it came off in light of the Bayes decision. When you look at that and you realize Idaho brings it back in 2023, they bring it back because it's not reliable to believe they're always going to be able to get the chemicals to execute somebody. And that's the real problem here. The firing squad hasn't been funded well enough to be built.
I think they're building it right now, as I recall from the media at least, that the construction's actually underway, but I may be wrong about that.
Well, I haven't talked to the director of the Department of Corrections, and that's probably who I would take my word from if that's actually happening right now. I think there's some additional problems with the firing squad, though. I think there's some problems with the way our statute lays it out. It's lethal injection unless it's not available, and then it's going to be the firing squad. But the way that's written is that it's firing squad unless the director of the Department of Corrections says I have the chemicals and we can do lethal injection. And I think there's 5 days that exist for the director of the Department of Corrections to say, no, we have the drugs, we can do lethal injection now. That is problematic. There's not a choice or an election, and other states have an election for the condemned person to choose from, but Idaho's not allowing that. Additionally, the information that I think is really important to the court is to understand things and advances that have happened in understanding conscious pain and suffering. If Dr. Wolf had been allowed to testify, she would tell you that she relies on studies from 2010, a working group from 2010, and a book that was published later than that even, and that's post the Bayes decision. And that talks about understanding what a person is conscious and aware of when they face the firing squad. That's information that's important for the court when considering whether or not to strike the death penalty, because Idaho's means of execution really doesn't exist.
Even if your motion were right, and even accepting as true that the current means of execution are either unavailable or would violate the Eighth Amendment as cruel and unusual, how do you get around Buckwell? You've not provided a alternate means of execution.
Well,
and I know, and I understand from your perspective, it's not something defense counsel wants to do, is to say, no, do it this way. execute my client this way. But Buckwell provides that if you're going to challenge the means of execution, you have to, as a condition precedent, provide a available or an alternate, I should say, means of execution.
I would say, to Your Honor, that we're not at the place where we would have to make that decision yet.
That speak to the justiciability of the issue overall.
I don't think it does. And I think that the separation and the difference is that we are in a place where we're preparing this case to go to trial. We represent Mr. Koberger, who sits there, an innocent man right now. And so I think when we're looking at the constitutionality of the execution, I think that's different than if there was a conviction and if there was a death sentence and if the post-conviction proceeding and the appeals were unsuccessful for Mr. Koberger.
Doesn't that speak to your motion in the sense that you're saying take the death penalty off the table, don't let the state put on that evidence because the current methods, in your view, are either unavailable or unconstitutional? But the reality is if he is convicted, we know it's going to be a decade plus before that sentence would be carried out. And who knows what the methods may be then. And, I think that's part of why you're saying you shouldn't have to comply with Buckwell. But it seems to me that that same rationale then applies to why I should even consider this motion. Why wouldn't we wait until that time frame to see what the current methods are?
I definitely hear what the court's saying. I would come back to saying that we're not in the place where he's challenging the methods that's about to be employed. We are decades away from that, if that were to even happen. But what I'm saying is I don't believe that our Constitution allows for us to move forward and make him sit on death row for years and years and years when the way Idaho's doing it right now isn't really working. It's not a realistic option. I think to have him sit on death row and say, Idaho's going to figure out how to kill you at some point in the future in a way that isn't cruel and unusual and in violation of your rights, I just don't think that the constitutional protections allow that to happen. I think that.
So you're saying the anxiety of not knowing is the constitutional violation?
I say that, and I believe that the Troop versus Doles was cited in the brief, and the comparison there is what I'm saying the Constitution doesn't allow. It is anxiety, it is fear, it is the not knowing.
I mean, to be fair, the Idaho Supreme Court just ruled that anxiety and fear in the Creech case was not sufficient to preclude his execution just this week.
I read that opinion, and I read that, I guess, more particular to the botched execution attempt versus sitting there for decades and not knowing how and if it would happen.
No, but it was anxiety that was the underpinning.
I don't mean to disrespect what Mr. Creech felt or went through, but you're talking about realistically from February 29th, if this was leap year, until now, and what you're talking about for Mr. Koberger and what would happen if he were convicted and if he were sentenced to death would be decades. The court just acknowledged that it's decades to sit. And so I understand what the Supreme Court said. I did read that too. But I think it's different when you're just starting out here in this circumstance.
I want to start by pointing out, one of the things that Ms. Taylor just said was, looking forward, we don't have the answers to that yet. Well, that's the whole point, is this just isn't right. We don't know what's going to be available decades from now, and it probably will be decades, plural. If you look at, Idaho's track record, Mr. Creech, Mr. Pizzuto, they were convicted back in the 80s.
Take as true, for the purposes of my question, that the state doesn't have a method. Should defendants be tried for and potentially sentenced to death when the state has no method of execution currently?
Yes, Your Honor, I don't see a problem with that because deciding the method of execution is not deciding the sentence. The sentence is death. The method of execution is just how that's brought about. And so even the United States Supreme Court has recognized that someone who was convicted and sentenced to death, in that case, I believe it was hanging, and then after he was sentenced to death, the state passed a law, made it electrocution, and the U.S. Supreme Court said there's no ex post facto problem with that because you're not changing the penalty. The penalty is death. And so even if you assume that Idaho cannot do lethal injection, and even if you assume that the firing squad is unconstitutional, that's not to say that decades from now, there is not going to be a method by which the state could put him to death. And then, of course, I was accepting the hypothetical as proposed, but we would strongly push back on this idea that Idaho doesn't have a method of execution. There was a scheduled execution to take place on November 13th, just days from now, that was only stopped because the federal district court entered a stay so that it had time to consider some additional claims. But in that case, Director T-Walt put in an affidavit that said, we have the chemicals, we can do this. We've modified the procedure to address the individualized problem that came up with Mr. Creech before, and so we can execute Mr. Creech. So there really is just no evidence whatsoever to suggest that Idaho can't do this, and certainly not that it can't do this decades from now. And again, that gets back to the ripeness issue is it may be lethal injection, it may not, it may be some other method, but we just don't know enough now, frankly, to spend the time and the effort debating what we don't know in the future. That's the entire reason the ripeness doctrine exists. I also want to speak just briefly on the Bucklew point that the court brought up. What I'm hearing from the defense is they just have this kind of like vague Eighth Amendment assertion of maybe it's kind of the anxiety, but kind of not knowing how you're going to be executed. Well, that's not how the law works. There's an established framework of how you can make an Eighth Amendment method of execution claim. And Bucklew, the court specifically said, I'm quoting here, identifying an available alternative is a requirement of all, and all is emphasized in the decision, all Eighth Amendment methods of execution claims. You can't get around that by just saying, well, but I'm making a slightly different kind of claim. It's not a method of execution claim, it's a means of execution claim. That just doesn't work. That's not how the law operates. And so they haven't even suggested, even today, an argument what a proper alternative would be, which also gets back to the ripeness issue, which is we don't know decades from now what an alternative might be. Maybe they'll have a better argument decades from now on the method of execution because maybe there will be a better method. And that gets to the final point I want to bring up, which is the remedy here. They're asking that the death penalty be struck because these methods are unconstitutional, but that's not how it works. If you show that one method is unconstitutional, part of the reason you have to present a viable, readily implemented alternative is so that the state can then use that method for the execution. You don't get to, at the beginning, short circuit the whole thing and say death is off the table because the current method is unconstitutional.
The distinction is not us being on death row with a death warrant that we're talking about. That's a different kind of conversation. We're well before looking at the overall picture and saying the Constitution protects somebody from sitting in prison when there's not a real means to execute.
Do you
I
have
understand.
any case that says that?
I'm making an analogy with the troop versus duels and the denaturalization with the dehumanization that happens if somebody sits on death row when there's not a realistic way to execute. I understand that lethal injection has not been overruled. I understand that. But when we're talking about the recent history of what's happened in Idaho, there are problems. And we're talking about way back here when we're sitting with constitutional protections and Idaho's got all these problems with executing somebody. And how is that right, fair, any protection under the Constitution for somebody to have to sit there and just wait for Idaho to figure it out? That's the difference in our argument.
We are asking the court to strike the death penalty because in Idaho, there is no narrowing of eligibility, which results in arbitrary imposition of a death sentence. We are also asking the court to strike the death penalty as a violation of the Equal Protection Clause. I will argue narrowing first. When it comes to the determination of eligibility, it begins with the definition of first-degree murder. And when the definition of first-degree murder is looked at, then the next thing that happens is looking at statutory aggravators. And the reason that those two things exist in Idaho and those steps in analysis exist in the United States is because of the Furman case. It's important to distinguish between eligibility to be charged and selection, which is at a post-conviction phase of a case. And so our argument and our focus for this issue is on the eligibility phase. I want to be clear about the argument and eligibility, that I'm talking about the definition of first-degree murder and the aggravator statute, because our definition is so broad that there is no narrowing there. And so that is an important first step that the prosecutor, in their discretion, they're looking at, and there's essentially no guidance with the first-degree definition. Professor Cover concluded that when you analyze those things with the 195 cases that she reviewed and collected data on against the number of death verdicts, which is so low, that you end up with a statistic that is worse than the statistic that the Supreme Court struck down in Furman.
Well,
And
so the Furman's an interesting decision, right? Because while I recognize two of the justices talked about those specific statistics, I don't know that those specific statistics are in fact a binding opinion of the court.
And I don't disagree with that, but it's certainly guidance for the court. You know, when you're not hearing testimony from the expert to explain everything that was taken into consideration in the conclusions that she drew, then what I'm going to do is take it at the high level that Furman is the guidance of those statistics. Her statistics show that Idaho's were vastly worse, and so it's certainly something that the court needs to take into consideration in terms of whether or not there is the ability to narrow in the state of Idaho.
The analysis by Dr. Cover in her extensive law review article takes as its starting point that you have to have a statistic below that identified by the two justices in Furman.
Your Honor, I guess I disagree that that's where she draws a hard line there. I think that it's guidance.
Okay.
So the problem when you have no narrowing is that instead of it being a situation where the worst of the worst are being charged with the death penalty, everyone falls within that category. And that cannot be remedied by anyone else other than the legislature, because that is their duty. And if there's no narrowing, then and it's arbitrary, then that's a basis for this court to strike the death penalty. The other point that I want to make about our motion on this is the issue of geography, and I want to point out that we are arguing geography in the context of equal protection.
As I understand your analysis, is that the geographic, there's a predilection for capital cases to come from geographic centers of large populations, correct?
Correct.
Your client's case does not stem from one of those.
That's true, Judge, but this is not, we're not talking about the facts of our client's case right now. We are talking about Idaho's statutory scheme.
On the whole, your claim is that it violates equal protection.
Correct. And not only on an Idaho level, but also on a national level when you take into consideration how many states have stopped using the death penalty or paused using the death penalty.
If I accept that there's an actual valid analysis to be done here, would you agree that I need to look at the cases since 2019 as well?
I think, Judge, the point of bringing in an expert today to talk about a study is that that's her expertise in gathering the information and putting it into a compilation. For you to engage in that on an individual basis.
Well, I can't take her opinion because it's a legal conclusion. Looking at her data, which is 5 years old now, it seems to me that if I were to engage in that, I would have to look at the data as of today.
Well, it could certainly be instructive, Judge, but if you're taking the data from Hairston, which was 1978 to 1995, and Professor Covers from 2002 to 2019, the data, if it was analyzed, I'm quite certain would support both of their premises. I think that there's enough guidance with all of those years of data to be able to draw the conclusion that it's arbitrary and capricious today, because the statutory language is still, the definition is still the definition, the statutory aggravators are still the statutory aggravators.
My understanding is an equal protection clause has to be analyzed as applied. You would agree if it is as applied, that would put your client's claim, at least as it relates to within the state of Idaho, as not being problematic, given that he's from one of the smallest districts in the state.
Yeah, I'm not going to concede that as applied, it just simply doesn't fit. I think that there are greater questions than that. But I don't have a case to point you to. It hasn't been raised in Idaho. We're making the first equal protection. In other district court cases in North Idaho, Mr. Logston has raised this issue, so I don't want to say you're the first.
All of those.
Right, but it hasn't made it to the Idaho Supreme Court, to the appellate courts.
Thank you, Judge. I'll try and keep this brief. I think there are two problems, independent problems, with the theory that the defense is articulating here, and they both come from Idaho Supreme Court decisions. The first, as this court has noted, comes from Hairston, where the court said this just isn't how you do the analysis. You don't cumulate them and then do
What's
the analysis.
intellectually wrong with that analysis, though? I mean, I understand the legal cases may not be supportive of the defense's claim, but from an intellectual analysis, if the point is to make the death penalty less arbitrary.
Correct.
Why wouldn't you look at the net or the cumulative as opposed to each individual compared on its own in isolation?
So, Your Honor, I think to answer that question, looking back to kind of how this was developed with the aggravating factors, the idea behind the aggravating factors is that you have to be able to show that this person is morally worthy of the death penalty. And so if you have individually analyzed every single factor and every single one you've found constitutional, then it doesn't matter if in every case you could apply one of those factors, because that factor is a reason why that person is morally worthy of the death penalty.
If you have so many aggravators that on the whole would essentially apply to any first-degree murder, then isn't it just left essentially to the prosecutor as to which cases are or are not worthy to bring as a capital case?
Absolutely, the prosecutor would have a lot of discretion in that. I don't know that I agree with the characterization that it's left to the prosecutor, because of course the prosecutor has to prove that aggravating factor beyond a reasonable doubt. And if they can prove one of those aggravating factors beyond a reasonable doubt to the jury, and the jury finds that, then that person is now worthy of the death penalty. When we instruct the jury, we don't instruct them to consider all of the aggravators in the aggregate. We tell them you have to consider them individually. We tell the state's required to present non-duplicative evidence for each aggravator that it's going to assert. It can't just throw out a blanket of aggravators. I think focusing on single aggravators is consistent from beginning to end of our entire system. And I would note, I think the court has mentioned this as well, it's not just the Idaho Supreme Court. There are many courts who have rejected this approach. The defense hasn't been able to point to a single court in any state, in any jurisdiction, that has used this cumulative approach to attack the death penalty or the statutory scheme of the death penalty in any state. The defense, in their reply brief, they tried to say their response to Hairston was, well, that was when judges were doing the determination, and I just don't see the relevance to that, logical or otherwise, how that would matter on the narrowing part. They point to Hidalgo, which they brought up multiple times today, which is a dissent. It has no binding authority. It has no effect whatsoever on the case. So they just can't point to anything to say that Hairston doesn't apply today. It does apply today, and the Idaho Supreme Court has rejected that approach. So that's the first reason why this fails. But then even independent of that, there's a second reason, and that is the defense is relying on this narrowing process that has been described by the United States Supreme Court. I believe the most recent case that they've kind of walked through that was the Tulipa case. And in Hall, our Idaho Supreme Court talked about Tulipa and exactly what that test requires. And in Hall, they were analyzing a single aggravator because that's how you do this. And it was, the court acknowledged that, yes, this would apply to many, many murders, but it doesn't apply to every murder, and that's all that Tulipa requires. So the way, even if it were appropriate to aggregate all of these circumstances, the appropriate narrowing question is, does it literally apply to every single murder? And even Professor Cover's analysis shows it doesn't. Your Honor, in terms of the equal protection claim on geography, I think, here again, they run into a problem with the Idaho Supreme Court. A similar claim based on geography was raised in Hairston, and the court rejected it. The court not only rejected it, the court instructed future defendants, if you want to bring this claim, here's what we're going to need to see. And they said, in order to show that the imposition of the death penalty in Idaho is arbitrary and capricious, there must be some empirical evidence connecting the discrepancy that appears to be shown by Dr. Jensen's study and one or more impermissible factors. And the defense has been aware of that, and instead they bring a study where the person who conducted the study acknowledges, I can't show that. I want to end just by talking a little bit about the court's question on would you have to look at the data up to today? I think the question or the answer to that has to be yes, absolutely. There's no reason why the date Professor Cover conducted her study has any legal relevance or significance. It would be up through today. And I think this goes back to a problem of this whole accumulating the aggregating factors and then doing a mathematical study and finding a percentage, because let's say that courts engage in that conduct, and let's say the courts decide it's 50% is the magic number, and if you get above 50%, then your statutory scheme's unconstitutional. Well, what if Idaho is right at 50.5%, so it's unconstitutional, but then over the next year, a bunch of murders are committed and none of them satisfy the aggravating factors, so now we're at 49.5%. Now everyone in that year can be subject to the death penalty because the murderers that committed murders that year decided to do it in a way that didn't satisfy one of the aggravating factors. I don't think there's a logical basis for that. And I think that's why the Idaho Supreme Court has taken the approach they have, where this isn't a quantitative analysis, it's a qualitative one. Is there any narrowing that's being done? And if the answer is yes, then you've passed the test. That keeps things fair and uniform across the state and temporally across time.
Address the geography issue?
Yes, Your Honor, I addressed it briefly. I'm happy to talk about it more.
It seemed to me the defense had raised some issues that perhaps were a little more expansive than what they had argued in their brief, and so.
I would certainly agree with that, Your Honor. So a couple of things on that. First, the idea that it somehow violates equal protection for Idaho to apply the death penalty when other states do not on a national basis. I'm not aware of any case law that would support that. And in fact, it's directly contrary to the case law that we're going to talk about later on evolving standards of decency, where the U.S. Supreme Court has specifically acknowledged that yes, there are some states that apply it and some states that do not. The conclusion from that isn't that just because there are some states that do not apply it, it's unconstitutional everywhere. With an equal protection analysis, really the first question you have to ask is, who are we talking about, and what status do they have, or what position do they hold? Because a critical part of the equal protection analysis is you have to treat people that are similarly situated the same. You don't have to treat people who are not similarly situated the same. So that initial determination of are they similarly situated requires a subject, a person. And so to the court's point, I think in the vast majority of cases, at least that I'm aware of, equal protection is raised as an as-applied challenge, as applied to the person bringing the challenge. And so in this case, where they're trying to argue that it's only the larger counties that seek these things, as the court pointed out, that's not true in recent Idaho history. And they, again, have not pointed to any study, Professor Covers or anywhere else, that shows that the reason why there are more death penalty cases brought in the larger counties is because of some unconstitutional reason, rather than, could it be explained by something else, like the fact that they are more appropriate in those areas. And frankly, the common sense understanding would be that you're probably going to see more death penalty cases in more populated areas, because just as a matter of statistics, there's probably going to be more first-degree murders committed there, and therefore probably more that are eligible for the death penalty.
The difference in an experienced judge being able to get into all of these nuanced areas and apply beyond a reasonable doubt in the gateway phase, and then just mercy in the mitigation phase is very, very different than a jury's ability to do those things when it's the only case that they're looking at. So I do think it's important to take into consideration the timing of where we're at now with the jury decision. And I wanted to also point out that the study dates amount to between 75 and 95, those years in Hairston, in 2002 and 2019 for Professor Covers. That's 37 years worth of data with the same definitions. So, instruction in a few more years of data, you've got 37 years to rely on, that there's no narrowing.
I'm only talking about the statutory aggravators, not the non-statutory aggravators or the mitigators. It would simply be...
Your brief says otherwise, so that's why I question that, because as we've learned, that takes a long time for those things to be developed. That's not necessarily evidence in the pocket of the state. What is now gone from a case timeline of several months to now multiple years would seem to me to even drag it out longer.
But I don't think what our position is that the state would be required to put on essentially their entire sentencing hearing in front of that grand jury. The grand jury is still only determining whether or not there is a reason to go forward with the case. Our point is that at the time of the founding, that grand jury would have known that all felonies lead to the gallows. So at that time, the grand juries were making decisions about whether or not people were going to face the death penalty. And it wasn't until the Supreme Court after Furman in the 70s that we came up with this entirely new system, but it's one where the grand jury has lost its part of its function, where it's looking at whether or not these people should be facing the death penalty or not. Essentially, they were deprived of that through the transition that was obviously intended to protect people from an arbitrary infliction of the death penalty. But the grand jury itself is supposed to also have a role in that. It's supposed to protect people from arbitrary decisions. And so that's essentially what our argument is that there should be a neutral fact finder placed between the citizen and the state when we're making the decision whether or not the death penalty should be sought. And so that is one of the reasons we're asking the court to strike the death penalty in this case.
Your Honor, sounds like on Abdullah, this is just a issue of issue preservation, so I don't have much to comment on that. In terms of this other argument that they are saying you can look at it differently through the Eighth Amendment, Keep in mind the Eighth Amendment is just the prohibition on cruel and unusual punishment. It's quite a stretch to jump from there to requirements on what needs to be presented to a grand jury. The Beck case that they cited suggests that maybe there could be a connection if that diminishes the reliability of the sentencing determination or the guilt determination, but that's not the function the grand jury plays. And so for this court to stretch the Eighth Amendment all the way back to the grand jury would be.
In fact, with respect to failings of a grand jury to pass on a particular element, for example, if there's then been a trial, the general standard on appeal is, well, the matter went to a jury and they made the determination there's proof beyond a reasonable doubt, and therefore any error is moot.
Correct, Your Honor. And I think really that gets to the heart of this claim, which is it's just kind of another way of their argument that it shouldn't be the prosecutor deciding that a notice is filed. And the U.S. Supreme Court has said it's not a problem if the prosecutor has unfettered discretion in who gets the death notice and who doesn't. So that by itself isn't a problem. So,
Well, I think it would be best to push back at least a little on the idea that the Eighth Amendment can't go back that far. I mean, recall that it was the Eighth Amendment that required that there be counsel for people that were facing the death penalty. Now, I certainly understand the idea that the Eighth Amendment's concern is that we have a reliable procedure. I certainly understand that. But the grand jury, it does fulfill some of that function as well. And besides, at least if we're speaking in terms of what was understood to have the grand jury and what it did at the time that the nation was founded. And so I do think that the Eighth Amendment has the ability to attach even that early on, at least in cases involving death. I recognize that there are these cases from the Supreme Court indicating that prosecutors do not have to have anybody determine whether or not they can file the death penalty and that they can drop it out of a sense of mercy. I think that's a slightly side question to, if they choose to go forward with it, who can stand up and say, before we spend years on one of these cases, that this is not the appropriate case, someone besides the prosecutor. And so we still believe that the argument here is one that can be passed on by this court and that hasn't necessarily been ruled on by these other cases that we also think should be overturned.
Let's finish up topic 9 with your contention that the death penalty should be struck because it violates international law.
Thank you, Your Honor. Essentially, the argument comes down to this. We have signed and ratified a treaty that would put, we think, additional requirements on what we would do if we're going to have a death penalty in this country, and obviously we have one. One of those is a requirement that we make sure that we're not arbitrarily killing people. And the other one is that people are not being essentially tortured.
My understanding is when the time that convention was ratified with the understanding that to the extent that it is agreeing to anything, it is agreeing to afford the Eighth Amendment protections.
That's correct, Judge. I think if what we're saying is that the state would argue that we read the Eighth Amendment and that's what the international law must be, we're saying you have to read the international law to decide what the Eighth Amendment.
Right. So you're having the international law dictate what the United States Constitution means.
Correct. And we are doing that on the basis of what the United States has said itself about the fact that they believe that they live up to these things. I think particularly in this case, where the United States has essentially said, you know, we signed on to this treaty because we live up by these same standards that everyone else does. We can look at what the international community thinks about those standards that we said we also abide by when we're determining whether or not we're living up to the standards in the Constitution. And
well, what they said specifically is that we think that we are living up to those, even though we have and will enforce a death penalty.
And I think, which is why we're not saying necessarily that the death penalty would be struck if it was done properly. Our argument is that way that Idaho has its scheme set up, there are far too many statutory aggravators, and some of them are just big enough to drive a Mack truck through. And so just about every murder could be charged and have the death penalty attached to it. And so that doesn't require the narrowing that we've said we're going to provide, and it certainly doesn't live up to what the international community would expect from us.
Yeah, I understand the argument.
Well,
I'll be frank, it's falling about as flat as you would expect it to fall before our Supreme Court or the Supreme Court of the United States.
well, Your Honor, it's an argument, and it must be made, so
You need to make a record.
thank you, Judge.
All right, let's talk about the contemporary standards of decency.
Essentially, the court has said that when deciding what contemporary standards are in terms of what's cruel and unusual, that the court first looks at what the state legislatures are doing and then makes a decision based on its own determination of what it is it's going to be. But when we look at those cases, they also look at other things. They look at international law. They look at what religious organizations are saying. I mean, they're obviously looking for what's the consensus going on.
I think Idaho Supreme Court said is what we look at is legislative and governmental determinations and actions.
In those cases, the number of states that still allowed the death penalty, I think, was around 35. And as the court, as we noted, that number has dropped somewhat precipitously since that time.
And those would be the legislative activities. I think what I was, taking issue with is the idea that they would look to what religious and other sort of non-governmental advocacy groups would argue or accept.
I don't think there's anything that says that the court can't look at whether or not organizations have moved against the death penalty. We are becoming somewhat alone in the world in terms of continuing to make use of the practice. The number of states that are still doing it is shrinking. And so when you look at that total fabric, it's our contention that we've reached the point where the death penalty really ought to be abolished. And so that is our contention in this case.
Thank you, Your Honor. While Roper may have looked at some international law, I think the Idaho Supreme Court has really narrowed that window. First in Abdullah, they said, therefore, absent some legislative or executive action, a determination by this court that Idaho's death penalty statute is unconstitutional based on evolving standards of decency and public opinion is unsupported. So they're really looking in at that. And fast forward 5 years in the Hurston decision, 2020, the Idaho Supreme Court reaffirmed that view and then also said, quote, we continue to subscribe to the view of legislative bodies as the basis for determining a national consensus. And so, and the reason for that, they explain in Abdullah, is that courts just aren't good at taking a temperature of public opinion and what represents society's views. Now, looking at the states that have capital punishment, according to the resources both sides have cited, there's 27 states that still have it on the books. That's a majority. They've pointed out that there's gubernatorial moratoriums in 6 of those, which is true. But that means worst case scenario, there's 21 states that still have the death penalty on the books and can use it. And what the Idaho Supreme Court said in Hurston is that we're looking for a national consensus. And we're nowhere near a national consensus that the death penalty is somehow immoral or improper or indecent. If what you're trying to show is a national consensus, it is not enough to just point to the fact that a state doesn't have the death penalty. You would have to show that the state removed the death penalty because that state believed that it was immoral or improper. So, for example, if a fiscally conservative legislature just decides they don't want to fund the death penalty, but they have no moral objection to it, that's not evidence that there's some societal standard that would.
What do you take of evidence from a state who is not enforcing the penalty because, for example, an executive of that state is morally opposed to it and has the power to preclude it from being applied? Should that be considered?
So the Idaho Supreme Court did mention executive action, although in Hurston they seem to say the better picture is painted by legislative bodies. And I think part of the reason for that is because the executive, it can just depend on the administration that's in power at that moment. A perfect example of that is the United States. The death penalty is on the books. It's currently not being applied, but shortly before the current administration it was. And I think it's safe to assume that it will be again here shortly. The other thing you have to look at is, why is the executive doing this? For example, the defense cites that Tennessee has currently a moratorium. True, but the governor did that because he said we need to take time to fix the execution protocol. That's not evidence of a national standard that the death penalty is wrong.
So in a state like Tennessee, are they still in the sentencing capital sentences, but just not carrying them out, or have they stopped even trying capital cases?
I can't answer that definitively for Tennessee. My understanding is that they still try them and impose the death sentence, but that it's just not being carried out. I know that to be true, for example, in California, juries are still imposing the death penalty. I know in Ohio, another state that they've pointed to where there's a gubernatorial moratorium, there are 30 scheduled executions in that state. They keep getting pushed back, but the reason they're getting pushed back and the reason for the moratorium is they can't find chemicals to do lethal injection. Again, that's not evidence that there's some standard of decency that's keeping them from doing this. They just can't find the chemicals to do it. So I think...
Well, I mean, you could imply that the standards of decency as applied by the pharmaceutical companies who refuse to take part in it is some measure of that.
Potentially, yes, but I think, again, going back to the Idaho Supreme Court's decisions, we're looking specifically at executive and legislative action. And the fact that the legislature or governor is saying we would do this, but we can't get the chemicals, is actually evidence that they still support the death penalty. So I think no matter how you read the numbers, we're not at a place where there is a national consensus that the death penalty is indecent. And so we think the court should continue to follow what the Idaho Supreme Court said in both Abdullah and Hairston and reject their motion.
I would caution the court trying to figure out why it is that a particular state either dropped the death penalty or imposed a gubernatorial moratorium. I mean, I think that these things are complicated. That looks an awful lot like trying to figure out from legislative history why something occurred. Half the time, what you see in the questions doesn't necessarily tell you what the legislature had in mind when they finally voted. And so I think the first step, as the United States Supreme Court has set it out, is just to look at the numbers. And then after that, the courts can consider other things.
There are 21 if you take into account moratoriums. How, I mean, certainly more than a third of the states, how does that represent a consensus?
I would argue that the consensus can also come from the trajectory. So the fact that so many states dropped the death penalty within the last 10 years, and that appears to be the direction that things are going, is something that the court can take into account. I also note a lot of these states that have death rows and don't have a moratorium still aren't actually executing anyone. And so the actual number of executions in the states that are actually executing anybody is less even than that. I think it's something like 13 jurisdictions that are actually doing executions. Anyway, for those reasons, Your Honor, we are asking that you strike the death penalty.
Thank you. All right. Well, thank you. Everybody have safe travels back. I will take the matters under advisement and issue written opinions forthwith. Thank you.